All right, in the meantime, we're less than an hour away now from closing arguments in the case that could make Donald Trump a convicted felon or perhaps give him a huge political boost. With us now, CNN legal analyst Jennifer Rodgers and former prosecutor Jeremy Saland. And Jennifer, I want to start with some of the details that we are learning about what might be in these closing arguments. CNN has learned that the defense might focus on who did not testify in this case. Alan Weisselberg, the CFO of the Trump Organization, and Keith Schiller, Trump's body man. How would you bring them up in closing arguments? What would you do with them, and what's the risk reward?
Well, the defense says you heard about this Alan Weisselberg. Michael Cohen is the only person who tells you that Trump was in the know, that he knew about the reimbursement scheme, but he says Alan Weisselberg also knew. So where's Alan Weisselberg? Prosecutors didn't bring him to you. Where's he? Where's Keith Schiller? They claim that Keith Schiller was on the phone when they were talking about these payments and so on. Where's Keith Schiller? I mean, that's the way you do it, which of course implies that prosecutors could have brought them and should have brought them and didn't bring them. And then the question is, we were talking about this before, what kind of instructions do prosecutors get? Not about Keith Schiller, who either side could have called. If they wanted to, they'll probably get a missing witness charge with respect to him. But with Alan Weisselberg, who of course is in prison for perjury, having lied to protect Donald Trump at a previous trial, and who also would presumably invoke the Fifth, right? And of course has the severance agreement where he's agreed not to voluntarily cooperate with law enforcement or he foregoes $2 million. So there are lots of reasons he's not there. The question is, if the defense raises it like that, I have to assume the judge gives an unavailable witness charge saying to the jury, he's not here, he's unavailable, neither party can call him, you are not to speculate as to why, and then just leaves it at that.
What does the prosecution do with that, or how much do they care about how the defense uses Alan Weisselberg in closings?
Well, I think the prosecution has to bring it back to really to the meat and potatoes here, which is the four corners of the charges. This is a falsifying business records case. You heard from Michael Cohen, you heard from Stormy Daniels, they gave you the background. You heard from Hope Hicks, you heard from David Pecker, you have the handwritten notes, you have the call logs. There's so much evidence that you don't need that you don't need Weisselberg. Those notes are so critical. They really poke the dots or put the dots together and connect it all together. But at the end of the day, whether or not you have Weisselberg, you have the case if you believe the evidence. And the evidence, I think, went in very, very well. And constantly, what the defense is going to try to do is make this about missing information, about lies, and about blackmail. And every time they do that, although it's not back and forth anymore, the prosecution has to bring it back down to really the meat and potatoes, I use that term again, that this is really a simple case of falsifying business records, not about sextortion, not about whether you like Michael Cohen, and not about where Michael Weisselberg is.
Which side is going to do more harumphing in the closing argument, which is to say, where might we see more passion? Because as Jeremy lays it out right there, he's suggesting the prosecution, who goes second here in the closing arguments, may be relatively dry and say, just look at the documents here.
Yeah, that's how it usually goes, right? Prosecutors have to take the law as the judge will instruct them and then kind of put the evidence in for each element of the case and say, this is how we've proved it. It tends to be pretty dry. I mean, hopefully they'll have some dramatic flourishes here and there to keep it interesting. But the harumphing and the faux outrage and all of that definitely comes with the defense. They're the ones who are saying, our poor guy is on trial here. This is an outrage. He's the president. You know, all of that will get more from the defense for sure.
And the jury won't get their jury instructions until Wednesday, likely tomorrow, right? Tomorrow, which is when we will be learning about them for the first time. But the lawyers here, they know, don't they, what's in these jury instructions at this point?
Absolutely. And when they do their summations, they're going to keep that in mind. They're going to make sure they hit the elements of the crime. They're going to make sure that they identify any issues that may come up with those jury instructions. So, for example, if there is a risk of a witness who isn't going to show up and there's going to be an instruction as to a missing witness, which probably won't happen, they're going to answer that in their summation. They know they're going to telegraph it and they're going to answer it before it gets to the jury.
I mean, to the point, it's almost like when you get an assignment, you know, to write a history paper about X, Y, and Z, you literally, in your introduction when you're in high school, say those words X, Y, and Z. Are the lawyers here mapping their closing arguments based on the jury instructions so it's like meshed together?
Prosecutors do. Defense lawyers tend not to. You remember, prosecutors want it to be organized and focused and tight. I mean, before PowerPoint was such a thing, we used to even have our paralegals put together like a poster board, right, where you'd put the elements of a simple offense and you would check it off. Here's the evidence that proves this offense, check, you know, so on. Defense lawyers want to do the opposite. They want to say, this is messy, this is complicated. I don't expect that they will do it like a, you know, here's what evidence fits with this. Instead, they'll say, this is all over the map. There's so much reasonable doubt. You know, that's the sort of thing defense does.
What percent of the defense closing arguments, and again, they go first very shortly, how much of it will be about Michael Cohen? If I say 75%, do you take the over or the under?
I take the over. I take the over. I think if the defense can make this about Michael Cohen, they can succeed. That has to be their objective. It is not about falsifying business records to the defense. It's not about anything other than a blackmailer, sextorter who has an agenda, and a bad dude who you wouldn't want to be with your sister or your in your family as your brother-in-law or anything like that. You wouldn't want it to be your darn neighbor or walk your dog. You cannot trust him and make it about Michael Cohen. That is their objective. Forget the falsifying business records, because if you make it about him, you can potentially win that case or hang the jury.
Hang the jury. One juror. Just takes one to hang the jury. So are you making, if you're the Trump team has been looking at this jury for 5-6 weeks, are you making the case to one or two specific people?
Well, you have to think about your viable arguments. You make it to as many of them as you can, because different things resonate with different jurors. Like, there's some technical issues around the enhancement, right? Around whether you can enhance the falsification of business records to, conceal another crime, right? If you think that the technical folks, like the two lawyers on the jury, are amenable to an argument that that's bogus, that you can't make that out, then you direct that argument to them. You're kind of picking all the arguments you have that might stick to the wall and saying, we may have 5 or 6 of these folks that might be the one.
And, we're going to learn a lot about what's in the jury instructions today based on how these attorneys argue the case in closing arguments. So a lot about to happen. Jeremy Saland, Jennifer Rodgers, thanks to both of you. Appreciate it. Kate?